Generally, when an action is filed in a particular jurisdiction's court, that court applies its own choice of law rules to determine whether it should apply the substantive law of a different jurisdiction. But what if the parties contractually agree to use a different jurisdiction's law? The Second Circuit considered this question in Siegelman v. Cunard White Star Limited. In September of 1949, Elias and Eva Siegelman paid for a luxury cruise from New York to France aboard a ship owned by Cunard White Star Limited. The Siegelmans were then issued contract tickets for the cruise. On the front of the tickets was a promise that Cunard would provide the transportation, subject to specific terms and conditions. One of the terms required passengers injured on the ship to sue within 1 year. In addition, a choice of law clause provided that all suits were to be governed by English law. On September 24, 1949, Mrs. Siegelman was seated in the ship's dining room in a chair not bolted to the floor. Unfortunately, while she was seated, the ship encountered rough waters. As a result, Mrs. Siegelman's chair flipped over, causing her to fall and sustain injuries. After returning to New York, Mrs. Siegelman hired an attorney. 11 months later, Cunard's agent offered her $800 to settle the case, which was the cost of her medical bills. Realizing the contract included a 1-year limitations period, the attorney asked the agent whether he needed to bring suit to protect Mrs. Siegelman's rights. The agent said it wasn't necessary because there was an excellent chance of settling and the offer would stand open. A few months later, Mrs. Siegelman died, and Cunard withdrew its settlement offer. Subsequently, more than 2 years after the injury, Mr. Siegelman sued Cunard in New York State Court on behalf of himself and his wife's estate. Cunard removed the case to federal court. Cunard then moved to dismiss the complaint, arguing that Mrs. Siegelman failed to file an action within 1 year of her injury, as required by the contract ticket, and therefore Siegelman's action couldn't be brought under English law. The court agreed and dismissed the complaint. Siegelman appealed to the United States Court of Appeals for the Second Circuit.